All right. And you have two other witnesses I know that we discussed yesterday. What were their names?
So, good morning, Your Honor.
Good morning.
Christopher DeCoste on behalf of Hakeem Robinson. Our plan is to call former Officer Graham. He's in person, he's live.
Okay.
Based on the way that testimony goes, it's going to dictate who we call next. We'll know that right when he's done. We also have present, Mr. Shipes is going to be available via Zoom this morning. We spoke to him yesterday. We gave the information over to the state. And then also the other rebuttal witness who is outside. So at minimum, we're calling 3. At maximum, we're calling 5.
Right, so who are the other 2 than the 3 you've just mentioned?
Gibson.
Oh, and Ms. Ahmad.
Correct.
Okay. Now, are Gibson and Graham going this morning? Are they ready to go now?
My understanding is Gibson's out there. Graham is out there as well, too. Graham is going to be first. And then we'll know right at the end of that testimony what we're going to do next.
Okay. All right.
That would be the order. It would go Graham, Gibson, or Ahmad based on her scheduling. The young woman that we have that's the rebuttal witness, and then Mr. Shipes.
All right. I'll hear from the state.
That's fine. We object to, we have no problem with the 3 category A witnesses the state listed. And I will say this for the record, yesterday, I indicated that we are agreeing to it because the lack of prejudice. I do think that there is significant prejudice for the defense not listing the category A witnesses from the state. There is prejudice. I was a little flippant when I said that yesterday. The state does not believe that their exclusion would be the proper remedy for the prejudice that we've suffered because those witnesses were all deposed. So because we have depositions of them, although we could not prepare for trial for them, it would be, the state's position is it would be unreasonable to exclude them as witnesses. So we have no objection to all the state witnesses. We do have objections to the witnesses that were emailed to us last night because those were not category A witnesses. We have not deposed them. We have not spoken to them. And we are severely prejudiced, and I see no other alternative that can remedy the state's position other than exclusion. So we are objecting to those witnesses.
All right. So I will need to conduct a Richardson hearing. There being a discovery violation, and that is those witnesses not ever having been listed by the defense. Is that correct?
Well, no, Judge. One of them have been previously listed since the day of the Arden hearing. So they were listed as a category A witness, which state was on notice of over 4 years ago. That's Mr. Shipes.
Who testified at the bond hearing?
Correct. And he was listed, and even though he wasn't formally listed after, they are on notice that he's a witness. And not to mention, Judge, if you recall, they are the ones who introduced the contract that was done by Mr. Shipes.
Well, that has not been introduced into evidence. Let's just make that clear. That was used to refresh a witness's memory. It's not been shown to the jury.
But just like how the state throughout the course of the past 2 weeks will bring up something in particular and go, it's not a discovery violation because it's been provided to them in this budget of the discovery. Just because an automatic exclusion just because they'll take it to someone as a witness,
I am aware that that is not the go-to sanction for failure to disclose. I'm trying to right now just get a baseline understanding so I can conduct my Richardson hearing and make my 3 required findings. So first and foremost, I understand. You're saying Mr. Shipes was listed for a bond hearing. You would acknowledge he was not listed as a category A witnesses for purposes of trial. And Ms. Robinson was not listed at all in any way, shape, or form during the 5-year pendency of this case.
and that I will concede. However, I will also make the argument because I've dealt with this many times where they're like, oh, but that witness is listed in the supplemental report, so you are on notice. This is Mr. Robinson, Abdul Sr.'s biological daughter.
Okay.
She's living in the house. She is the one that was driving the wife and father. They have been on notice that she has information from this case from its inception. Nothing prevented them from going and speaking to her. I will concede, Your Honor. We never listed her.
And look, I'm going to give both sides the opportunity to make argument. I just need the simple fact of was she listed, was she not listed?
She was never listed.
Okay.
going back in the past.
In addition, and of course, the rules of discovery, 3.220, require both parties to have that obligation to list the witnesses that they intend to call at trials category A. I think we can all agree on that. I will also add in there that my trial orders that I have entered throughout the pendency of this 5-year case, first done in February of 2023 and most recently done on February 19 of 25, also requires the parties to provide to the court the list of witnesses that might possibly testify, so I could read those names out to the jurors to see if any of the jurors are related by blood or marriage to the witnesses or have any business or social relationships with them. And I read out this complete list of names, and I asked the state, I asked Defendant Whitaker, I asked Defendant Robinson, are there any other names? You would acknowledge that Mr. Shipe's name and Ms. Robinson's name were not read? Okay. That being the case, I need to conduct this Richardson hearing because these witnesses were not listed. Okay. So I need to understand first for Mr. Shipes and then for Ms. Robinson how you came to know about them, when you decided to list them or call them as a witness, and why, so I can determine whether this was willful or inadvertent.
So, the decision to call them is strictly because of the evidence that was brought out when the state was doing their rebuttal of Abdul Senior.
And what specifically?
When they asked Abdul Senior, which was a subject, I think, of my motion to eliminate, about people opining on who the shooter is if they are not there. Okay? So, they haven't.
You mean looking at the video and identifying Mr. Robinson?
Correct.
Okay.
No issue with Barner doing that. He was there. Any other witness who was present, because it's not an improper opinion, because they actually saw it. So, we were not, and they didn't even bring it up in their direction. It was in their rehab after we crossed, that is specifically wrong with that video. Mr. Abdul Senior testified he had not seen him all day. So, then they asked him, in your opinion, based on his body movements and things like that, even though he's never testified he's seen his son running or anything to that effect, gives this opinion, which in my opinion, coming from his father, is extremely prejudicial, and him just giving his lay opinion, yes, that's my son in a video where I cannot identify that. That's my son, and in my opinion, that looks like him, even though there's nothing identifiable. We did object immediately, Judge.
Yes, and let me clarify though, that came out both during the state's direct of Mr. Robinson and on redirect. So it came out at both occasions where they showed him the video and he identified. And we came sidebar, I think, on the first occasion to hear the objection, and I ruled then, explaining, of course, that the law allows somebody who is familiar with the subject to look at a video or a photograph and identify the subject. So are you telling me that the court's ruling was a surprise that this was going to happen? Because I know you all have deposed Abdul Senior, I think the first time in 23, so over 2 years ago, and then again in 24. He was deposed twice, was he not?
He was.
Okay. And presumably testified that he would be identified or would be identifying his son in the video. So that could not have been a surprise to now in the middle of trial decide, oh, he's identified him in the video. Because let me just say this, you all are smart lawyers, but you all know the case law. And 2nd DCA, 3rd DCA, 4th DCA, 5th DCA have all said that a witness can identify someone from the video. It does not invade the province of the jury. There have been cases where police officers have been able to identify. Parking security guards have been able to identify in video or in photographs if the predicate can be laid that they are familiar with the person, that they know the person, that they have some special relationship with the person that maybe a common person or a juror seeing it for the first time would not have. And that's especially true in cases in which the video or the photograph are not clear or don't particularly show the individual. And I'll just for the record cite a couple cases for these propositions that I'm stating, or not propositions, for the law that I'm stating. From the 3rd District Court of Appeal, we have Kopp, K-O-P-P versus State, and that is at 334 Southern, I'm not wearing my reader, so excuse me, Southern 3rd, 453, that the testimony of a parking garage security guard who identified the defendant on surveillance footage did not invade the province of the jury. The state is allowed to present this type of identification witness who is capable of independently identifying an individual from photographs, tape recordings, or similar evidence, or to simply support other identification evidence when that might be subject to challenge, assuming the state has laid the foundation.
And in that case, I believe that individual was a witness to the actual crime. That's where our issue was. I don't have a problem with people who are actually there opining that the person looks like the person that they saw in real life.
I don't know if this witness was an individual to the crime, but I'll cite just for the record, Day versus State. That's from the 2nd District, 105 Southern 3rd, 1284. Again, a police detective could testify that she recognized the defendant as one of the perpetrators in a surveillance video of a theft. Obviously, the detective was not a witness, but the predicate was laid that she was familiar with him from other communications and contacts. Likewise, in the 2nd District, Ratcliffe versus State. No, sorry, that's not the case. Anyway, and I'm only saying that to understand, knowing what Mr. Robinson would testify, knowing the law of the state, when and why did it take in the middle of trial, after the state is rested, after JOA, to list Ms. Robinson as a witness?
Well, Your Honor, if you recall, when we were at sidebar and we were addressing this issue, that Mr. Ksoo specifically said, if you are going to open this door, you have a courtroom of family members who are in a similarly situated position to give their opinion as to whether or not that is him, that you are now opening that door. So when it was going on, we actually raised that issue to them and reiterated there's a bunch of family members here. So I'm just letting you know. So we put them on notice in that moment. And I think that, Your Honor, that you can see, just so the record is clear, because each case obviously is very different. The case that you cited, I don't know what that video looks like. I don't know if the person's face isn't covered. I don't know if, there was something particular about the individual that the person is giving their opinion on. This case is different. The shooter is covered from head to toe. We have their own experts saying I can't say gender, I can't say race, any of those things. That's why I think this falls squarely within a unique place where he's completely can't look at the video and make a determination if he weren't there. Now, yes, he opined that in his, 15-minute interview when he decided to cooperate with the state, but it was our belief, Judge, even though we deposed him on that would not be admissible evidence. I haven't seen him all day long, and that our information, even though they put just Andrew Robinson Sr. and failed to call Shortron Williams, is Mr. Robinson wasn't fully living at the house there. He was living in and out. So just to say, like, our expectation was, because witnesses have been coming up with information on the stand that we didn't know before, of him saying he's only living there, we weren't on notice that they were going to lay that foundation to try and attempt to bring that in.
Well, they are required to before I allow that to come in.
And understood, this is just for us to lay judge. This wasn't willful. It was not willful, Judge. So that's why I'm saying that in the moment where we start, and if that was on the defense counsel for not knowing that specific case law, then that would mean that we were ineffective in not listing her before. So, and I will concede that, if that's the situation.
So
we should have known.
is her testimony, because I understood you were calling her for reputation. Are you calling her to look at the video and say that's not Mr. Robinson?
Correct, Judge.
Are you calling her for reputation evidence against Mr. Robinson Sr.?
I don't want to get into an area, Judge, where it's going to be open any doors. I will say that she is I'm not going to ask her, you were sitting here and watching your father
Yes, I just want to be sure about that, because you all kept saying yesterday that you might be calling someone from the audience for reputation, and that's a whole other decision I need to make in pretrial ruling of admissibility that I'd need to consider before allowing that in to see if that predicate is laid for reputation. So that being out the window then, your intention for calling Ms. Robinson is to show her the video to say that is not Mr. Robinson.
Correct, and I feel that the state is aware, and I will make her available. I asked her to sit outside this morning. If the state's in between and I want to take a break to be able to speak to her, since they're arguing, we haven't been able to take her depositions. They can speak to her before. Not taking deposition isn't, you know.
And then to be clear, since you've stated she's not here now, she has been here during the pendency of this trial this week and last week.
Yes, my understanding is, and I would have to ask her, is I do believe when she did at some point during his testimony get up and walk away when he said that he had no family in the courtroom. That's just so you know, I believe that she may have left during a portion of it. She is his biological daughter. Just to let the state and the court know the parameters of where I would go. I would say she was living at the house as well at that time. She saw Hakeem very frequently. She's very familiar with him. She was able to see the video on the media on multiple occasions. And in her opinion, is that her brother, Hakeem Robinson?
Okay. And tell me, state then, how you've been prejudiced or what other alternatives. If I gave you a break to depose her now, to speak to her now, to proffer her entire testimony here right now before we present it to the jury. It's that, or a mistrial or exclusion. As you know, and I will acknowledge, I think all parties can, exclusion is the last resort, it's the last remedy, and it could cause a reversal if I have not considered other less restrictive sanctions for the discovery violation.
I understand, Your Honor. All right, a couple things. I want to go back to, because are we still talking about Shipes as well?
We can talk about both of them, but admittedly, you will acknowledge Shipes testified not once, but twice at Mr. Robinson's bond hearings back in, I don't even remember, 2021 perhaps?
We shared with the court and counsel one of the YouTube clips, I guess it was maybe the second bond hearing.
That was the second bond hearing.
And so I don't think we have anything from the first bond hearing, but we have that. And in reviewing that bond hearing, the defendant repeatedly objected to the state's questions as being beyond the scope of the bond hearing. In addition, the court, rightfully so, but the court cut off the state's questioning as being far afield of what the issue was. So and if you watch that, we were exploring his basis of knowledge about how he knows, in his opinion, that the video is not the defendant. And those were objected to and then subsequently cut off by the court because of, we're here for a bond. It really doesn't matter to me the guilt or innocence of the defendant. The question is whether or not you can bond this guy out. We would not be able to depose this person because he's never listed. So, I mean, the fact that he's a record executive that would be willing to bond the defendant out gave us no notice as to what he's coming into this court and testifying to. I put him in the exact same boat as I do the daughter of Abdul Robinson. I think it is indistinguishable, those two.
And why, and what is the purpose of calling Mr. Shipes? Are you calling him for what? Are you going to show him the video and ask him to say that it is or isn't Mr. Robinson?
Yes, Judge, he's seen the video. He was with him for almost 2 years leading up to this incident. He's very familiar. He spent significant amount of time.
But he wasn't with him on the day?
No, Mr. Robinson Sr. was allowed to. He has the same predicate knowledge as.
Well, but that's the argument you're making about Senior, that Senior wasn't with him on the day, so he shouldn't have been able to identify him. But you're going to put on Mr. Shipes, who wasn't with him on the day, was out of state in New York, to identify or not identify Mr. Robinson?
But Your Honor ruled against us and said that he did have the basis of knowledge, so it should also apply to Mr. Shipes. He was with him the months leading up to it. He spent probably more time with him than Abdul Sr. So now, because you have allowed that in, he does have the basis to put in. And Judge, just so that the state is aware.
So are you telling me that you could not in any way, shape, or form have anticipated or were prepared in your case to present witnesses to look at the video to say that's not Mr. Hakeem Robinson? You weren't going to do that unless someone in this identify? And you didn't know Abdul Sr. was going to identify his son on the video?
I didn't believe that they were going to try to introduce what I thought was improper opinion testimony. And Your Honor, I know Mr. Rossi says, well, they weren't listed, I couldn't take their depo. The laws don't say that. They are free to take anybody's deposition they want. They don't need to leave of the court. They don't need to be listed as eight witnesses. As if they have a reason to believe that the person has first-hand knowledge, then they are allowed to send a subpoena, speak to them. So the fact that they weren't listed does not mean that they can't take his depo.
How are they to guess that you were going to show the video to a New York music executive and ask him to identify or not identify Mr. Robinson in that video?
I think he said it at the bond hearing, but Judge, it's reasonable. Everyone has seen that video.
I don't recall hearing that at the bond hearing because I think I sustained an objection.
He did say that, and then we tried to explore the basis of it, and that's when the objections were sustained.
All right.
So Judge, they're on notice. They were on notice from back then that he was able to give that opinion for something that they believed was admissible evidence because they sought to bring it out.
What I don't like is, I will tell you honestly, I expect both sides to follow our rules of discovery, to follow rules of professional conduct, ethics, civility, professionalism. This is not trial by ambush. To have a witness listed at 8:18 p.m. or sometime after 8 o'clock p.m. that has never been listed in the 5 years of this case, after the state is rested, after the arguments of JOA, I can tell you I don't like it. I can tell you the appellate courts don't like it. Now, whether or not I'm excluding, I haven't decided at the moment. I still need to hear further argument, but this is not how we handle trials here. Period. End of story. So, I need to know from the state, if I give you the opportunity to depose Mr. Shipes, to depose Ms. Robinson, if we break now, the jury can wait, I suppose, for you to talk to these people, will that be sufficient to satisfy any procedural prejudice that you believe you have suffered due to the defendant's lack of listing these witnesses for purposes of trial?
The answer is no. It will certainly help, and we'll do it as quickly as we can do it. The answer is no, because deposing someone 5 minutes before they go on the witness stand isn't the purpose of depositions. I can respect that the defense is proffering what they're going to say. What we need to do after putting them under, we have thousands of photographs we can show these witnesses and go through and see if they can identify other things. We have then background research to see whatever else this person has done in their life, talk to people that they deposed our witnesses for days, multiple times, and now in the absolute, when Mr. Robinson says, that's my boy, they're countering that with people that we've never even talked to. If we talk to them 5 minutes before, we don't have transcripts, we can't go and follow up on all the evidence that we have here and show those witnesses. It will take hours to depose these people properly. And so that's the prejudice. Our entire trial strategy may change because of this, which is completely unfair to the state. Maybe we wouldn't have asked that question. Maybe we wouldn't have asked Mr. Robinson that question, if we knew that other people were countering it. So there's a whole trial procedure from opening. We haven't mentioned these witnesses in opening. If we knew these witnesses existed, maybe we would have mentioned them in opening. Maybe we'd have gone through the process of all of our witnesses in our case in chief of building around how Mr. Robinson knows more than these other witnesses know. But we couldn't anticipate that they would call witnesses they haven't listed. That is the prejudice. And I know the court is aware of what trials are, especially this case more than others. The amount of time, effort, evidence that we've put into this case is unusual. This isn't a PFCF case where there's 2 witnesses or something like that. This is hundreds and hundreds of hours. I would also point out that the defense motion in limine that was filed in July that we heard, paragraph 2, they actually anticipated this exact issue by saying that they filed a motion saying that no officer should be permitted to give their opinion. And so it's shocking to me that the word no witness could have been included instead of no officer. The court can render its own judgment about whether that was intentional for what we're dealing with here today, or whether or not that was merely accidental that they just said officer instead of witness, knowing the only person in the case that was identifying someone from that video was a witness. and they filed a motion in limine saying no officer. And that was this defense motion in limine that was filed July 13th.
And Your Honor, I don't misquote cases, so the case that I cited to, the police officers, so I wouldn't put something in there to mislead more about the state of the case law that I am citing.
I was not saying she was misleading the case law. What I'm saying is, if they believed that Abdul Robinson's testimony was inadmissible, they 1,000% would have put it in their motion in limine. And that was the only direct evidence of someone identifying someone was Abdul Robinson. Yet they took the time to put in a paragraph, no officer will identify him, when none of the officers identified him from the video. So I submit to you that this was intentional. They intentionally did not put no witness because they didn't want the state to know that other witnesses would come into this court and give an opposite opinion of Abdul Robinson.
So he says I'm not saying it's intentional, but just argue that it's intentional. I take offense to that, Your Honor. I am saying that that is what I put in there based on the case law that I was aware of at the time. In my opinion, I did not believe that Abdul Robinson, just because Joe Cooper says, is that him in the video, doesn't make that statement admissible. So I didn't believe that that was a proper that he was a proper person to make that opinion.
Despite the case law that says he can absolutely do that?
Judge, the case law that you're citing to, it's, as you can see, I'm trying to differentiate it on the fly right now.
Okay.
So, and in those cases too, I would submit, and without looking at them and digesting them and studying them, almost positive that I could differentiate them with the fact that this is not the same situation where you have a video of someone who is completely covered. There are nothing about what he can say. He is not, for him to say, oh, he's running and his body morphology, that is what he tried to find. We objected to it because we truly believed that it wasn't admissible evidence. That there, Your Honor, is indicative of what we believed at the time would have been admissible evidence. So it's for them to argue that this was done on purpose is extremely disingenuous of an argument to me. We have been going through this trial. There are things that have been popping up on the fly that we have argued they should have let us know and change of testimony of certain witnesses, and that has all been allowed. So I'm just, they're saying that, oh.
Listen, I'm not saying, I'm here for this. I'm not going to rehash what testimony has already come up. Witnesses are impeached in trials all the time if they change their testimony from what it's been from deposition to current. Because that has occurred in this case for some witnesses, not others, I'm not, that doesn't play in my consideration. It's not like, oh, judge, because they did it, we can do it. Two wrongs don't make a right. I am here to decide these witnesses. They were not listed. What they have to say, whether it was inadvertent or willful, whether what they have to say or whether this violation was trivial or substantial, and then how and to what extent the state was prejudiced, and then what sanctions I can impose for the violation. It's already been determined they weren't listed. So that's why we're having a Richardson hearing, because witnesses who are intending to be called by the defense were not listed by the defense as witnesses in this trial. Their names were not provided to the court. And further, at least as with Ms. Robinson, the rule of sequestration has been violated because she's been sitting through the course of the trial, and you all invoked the rule of sequestration. Again, I realize that violating the rule of sequestration in and of itself is not sufficient for the exclusion of a witness. I'm looking at this in the totality. And again, I just go back to the issue, Ms. Kawas, with all due respect, of the defense being surprised to be admissible by Mr. Robinson. From all of these circuits is abundantly clear, and I will give you time if you need to read them. I don't want you to be on the fly about them, but I would think that from the Third Circuit, y'all's circuit, or the Second, or the Fourth, or the Fifth, y'all would be familiar that witnesses who have a specialized knowledge of the subject can opine about that witness's identification. And further, the appellate courts have specifically said that the state may introduce such identification testimony when a video does not provide clear images of the perpetrator. That's especially when it's most important, assuming the predicate is laid. And in this case, the state asked Mr. Robinson, and he testified that he'd been living with his son, that he had seen his son walk. He has been with him through other times. Admittedly, He served 10 years in federal prison sometime in the 90s based on another a conviction of his. So yes, he admits he was absent for 10 years, but otherwise, at least according to his testimony, if it is to be believed, to lay the predicate for the admissibility of his identification, the predicate was established. I understand you now want to call 2 witnesses that were not listed to look at that same video and say, no, that's not him. And so my question is, why couldn't you, separate and apart from Mr. Abdul Robinson Sr.'s testimony, have done similarly? Listed them, anticipated that you wanted to call them. Why now, in the middle of trial, after the state's closed and after JOA, are you now thinking, let me call 2 witnesses, Mr. Shipes from New York and Mr. Robinson's sister, to now look at the video that everyone has had for 5 years and say, no, that's not him?
Your Honor, and what our defense and how is their burden?
Yes, it is.
We are reactionary to them. We had no idea which witnesses they were going to call, which they weren't going to call. So these are witnesses who are straight rebuttal witnesses. So we don't have an obligation to actually list them until we know what it is that they're going to do. So, and the moment, Your Honor, that we found out, so I know Mr. Rodney gets up here and goes, well, we rested now. And we specifically said when that testimony, before they rested and called other witnesses over the weekend, because Abdul Sr. testified on Friday, we specifically said Johnny Shipes' name outside of it. We will be calling Johnny Shipes.
Do you have a case law rule or statute that says that rebuttal witnesses don't have to be listed?
Judge, I'm relying on the cases that I have where it specifically indicates that not listing, a case I sent you, Judge, was an alibi witness where the rule requires that that witness should be listed 15 days prior to trial, was listed 48 hours before he was called to testify, and he was allowed to testify.
Okay, well, all facts are different. I'm going by Ratliff versus State, 561 Southern 2nd, 1276, that holds that rebuttal witnesses are not accepted from the requirements of Florida Rule of Criminal Procedure 3.220.
And Judge, in response to that is, I can't know who I'm going to exactly deem a rebuttal witness until I see what they put on. We are in a different posture than the state of Florida. We have zero burden. This is a criminal case. I have no idea what they're going to do. They are at liberty to put on which witnesses they want and prove the case whatever they want. But they also have an obligation to do a full investigation. They were on notice of Shipes from years ago. They are also on
So does that then remove the need for the defense to list witnesses?
No, Judge, this is a unique circumstance, and I'm just taking it by step by step by step. If there was a witnesses that we could have just rested just like Mr. Wisco, but we don't know who were, I didn't have any clue that they were going to fail to call half of the eyewitnesses in this case. So we had to now push on a case and call those witnesses. They didn't tell us who they weren't calling. They would just tell us, oh, the next day we're calling this person. Don't call Raekwon Howard. Don't call Tarvon Williams. Don't call J.R. Smith. None of those witnesses were called.
Are they obligated to tell you who they're not going to call as a witness?
They're not, but Judge, I am obligated to tell them when I know I'm going to call someone. And I found out the moment that that witness entered in that evidence, and frankly speaking, as to Mr. Robinson, I was just talking to all of the family members yesterday to see which one. That's the reason I got it late. But Miss Robinson is someone that's within their control, not within their control, but someone that they were aware of. The wife in Paula that senior spoke about, it's her car. My daughter's car, that's her car. So that's someone that they were aware of at first-hand knowledge as it relates to this case. The fact that you only go to one family member and ask his opinion whether or not that's his son, that's on them for lack of investigation. However, we are here now, Judge, and they have been on notice. For them to now come in here as to Mr. Shanks and say, well, we could have accomplished that over the weekend, but we put you on notice when that testimony came up. As it relates to Ms. Robinson, she is outside, you can speak to her. The very narrow area of where I'm planning to ask her about the fact that she knows. I'm not too sure what other investigation, what you're going to show her 800 other videos of a covered up Hakeem Robinson to ask if that's him too?
They're entitled to ask whatever the questions they want in deposition. It's discovery purposes. This is what we're going to do, because it's now 9:40, and we have to do this test run with Ms. Ahmad, who's in the country of Jordan. I'm going to ask the state, well, first, we're going to call Ms. Jordan, or the defense is going to call Jordan, Graham, and Gibson. Then we're going to take a recess, and I'm going to ask the state to make its best efforts at deposing these two witnesses. Ask whatever questions you want to ask of them, take however long you want to take with them. We will have to recess these two juries. They will just be sitting in their jury rooms waiting. And then let me hear from you. If you have obtained whatever sufficient information you think you have, I'll hear further argument on prejudice, and then I'll make my decision. But I think we should at least take this first step of you talking to them, deposing them under oath, and doing whatever else you think you need to do to be prepared to question them should I allow them to testify. But so far, we've now wasted not 40 minutes of this jury's time. Let's do this Zoom test with Ms. Ahmad, and then let's get started with trial, at least with these first three witnesses for whom there are no issues.